nothing must get in the way of us putting together a good case, because all good prosecutions are undergirded or underpinned by good investigative work.
What? Bro, what are you talking about, man?
Hey, watch on man. Viewers and subscribers. The DDP Miss Paula Llewellyn has clapped back at Vybz Kartel. Vybz Kartel lawyers, Gaza fans, and the misleading media. And also to everybody and anybody who said she had a role in any form of corruption against the artist and giving Vybz Kartel an unfair trial. All of that and more when I come back, so I'm go and stay tuned. If you're not a member of the gang, please do so right now by liking the video right now. It's free, it not cost a thing. Subscribe. Tell a friend, tell a friend. Now that we got that all out of the way, hey, cue the intro.
Kaboom! You know it's Warlord representing What You Know! The world I forget the stats, you know. You know it's What You Know media, and it's Warlord, the Skystar leader. Kaboom! What You Know!
Yes, man, my people. So the DDP broke silence when she went on the RJR radio station and did an interview, clearing up some of the misleading misinformation that was put out by the media, she claimed. I have been made to understand that they have been saying that I somehow breached the Constitution by indicating that we didn't have a problem with the matter going ahead after it was brought to the judge's attention that there was the tainted juror. There are 50 odd lawyers who operate on my behalf of the DDP, but under the Constitution, the DDP is able to step into any cause at any time in the interest of justice, and neither the prosecutor who was there before the judge nor the defense counsel can prevent that. It was a Constitution power, Llewellyn said. An opinion was canvassed from everybody, defense and prosecuting counsel, but the judge, who is supreme in law, was the one who made the decision, weighing all the different factors, because he too would have been aware that previously a juror had to be discharged because she was put in the situation where it was quite clear she would not have been able to continue. So right, that's what she telling us, say, overall she had the power to step in the name of justice after hearing that the juror was tainted and trying to corrupt the other juror by giving them a bribe. So she stepped in and let the judge know, and the prosecution couldn't stop that from happening, neither the defense, because overall she had the power to do so in the name of justice. She then went on to say, every now and again I would pop into court for a few minutes to build up morale, because the case was very stressful not only for the prosecutions but the police and the entire office, for a reason I would not go into. On the day of Justice Campbell summoned her, she said after hearing from the judge and the foreman who was called and questioned, the two teams of attorneys were asked to what their opinion was. The attorneys of the defense were saying they didn't think the matter should go on. I indicated we shouldn't have a difficulty with the matter proceeding. We were saying 6 years they have passed and it was a very serious matter, and the judge could always issue a further and detailed instruction to the jury. In addition to the general instruction, he really wanted an opinion from us, and I indicated that we would not have a problem with the proceeding and that any risk for a decision coming down that would be adverse to us, we are the ones who would handle that risk. Alright, Paula, I just say you go wrong now. You get to me and say, you being the DPP, step in and you see all of this are going, you take it to the judge, and your judge look on you and tell you, basically, you know what I mean, this can cause a problem. You get to me and say, so I'm gonna call the prosecution and also the defense and ask the decision and the defense make, you know what I mean, for them voice heard and that their decision was not to continue. So basically, from this, so all jurors should have be dismissed and they get no juror and start back the whole process. Yes, the case was trying and mean upon the office and the police and everyone, but you have a right way and you have a not so right way, which make everything lead up back to yourself.
In light of the fact that we are now headed back to court with this matter, a prosecutor has to do what a prosecutor knows best. We are bound by the rule of law. The Privy Council have made a judgment and they have issued certain instructions, and it is for my office to prepare ourselves to meet the next hearing of the matter, which should be before the Court of Appeal, in making our submissions as it relates to the issue of a retrial. I don't think the ordering council has come down yet from England to the Court of Appeal, but I'm sure that once it is received, then they will send out notices to the counsel for the other side and to my office. I don't have the sort of remit or latitude that defense counsel have in the public domain to say anything, whether they are misinforming or otherwise. The prosecutor will always be held to a much higher standard. We know that there is going to be another hearing and the possibility of other things after that. The overriding objective in any criminal trial is fairness to the accused. And therefore, I have deliberately stayed away from making any public comment about the judgment, save and except in respect of that narrow area of law where the possibility of the amendment to the Jury Act to replicate Section 46 of the particular legislation, which was referred to by the Privy Council in their judgment, would, I believe, go a far way in enhancing the administration of justice in Jamaica. What I indicated and what I would indicate, this case has had a particular history. There are a lot of things that have occurred, which I will not go into, which have caused us at the office of the DPP right throughout to have to be very, very careful and to refrain from making any sort of commentary on the matter which may be misinterpreted by either the accused, their attorneys, or members of the public who may not be totally informed of the legal issues and may seek to act in a negative way on given the emotions around the matter. When certain things are done, remember we have context that you may not have. We are at liberty to look at it through the lens of it perhaps being an issue, looking at what is being said and what is not being said, which can act as an inhibitor if we were so minded in respect of us continuing to robustly do our duty, as we do in this case and so many other cases all over the island. Well, I believe we would be obliged to, given the strength of the case for the prosecution that was put up, and given the authorities and the case law, perhaps, as I reflect going forward to my retirement next year, I have been too successful in seeking to, and I'm happy about it, to sensitize the public, to sensitize the media, to try to explain a lot of complex issues. Very often, and I say this, when you have knowledge of the state of the law in any particular area, for example, retrials, the prosecutors are obliged to go on a particular path because the law obligates you to do it. Well, first of all, the public has to be aware that the issue of retrials, as far as lawyers, well, let me say prosecutors and the judiciary are concerned, has nothing to do with emotion. It has nothing to do with who the accused is. It has to do with the seriousness of the offense, the public interest, how perhaps expensive it may be to mount the retrial. It doesn't even have to do with what the likely verdict may be, but it has to do with a number of factors which have been outlined in what we would call the locus classicus from the Privy Council in a case called Dennis, the main case on the point. So even if you have other cases that have been decided in the Jamaican jurisdiction and other jurisdictions in the Caribbean, that case is always regarded as the case that is endorsed and is adopted, right, by the Court of Appeal. So it is the go-to case that any lawyer would go to first in looking to see what the Privy Council has to say about the guidance on retrials. So, as I said, it has nothing to do with emotion. Now, delay in the criminal law has been pronounced upon by many courts. The Chief Justice has a famous case called Mervyn Cameron in respect of the whole issue of delay. And although the delay was quite a few years, the Crown was still allowed to have the case tried, and Mr. Cameron was convicted. We have had cases where delay without more would function as an abuse of the process of the court. Were you to seek to try the case or to retry it, and the prosecution has no choice but to enter a null in the matter. So it will come down to both sides, as it usually does. We are in an adversarial system. We have the defense and we have the prosecution. We both, as lawyers, do our research. We put forward our submissions in writing, and then before the Court of Appeal, which would be consisted of 3 judges at this very high level above the Supreme Court, we put forward our arguments, we amplify them, and we sometimes are questioned by the judges, and then it is for them also doing their research to come down one way or the other with reasons usually. So I have seen where retrials have been ordered, and I have seen where retrials have not been ordered. It all depends on the particular case, and you know that each case has to be assessed according to the particular law, and most importantly, the circumstances of the case. On the particular day, we have the open court system. The media, on behalf of the public, can certainly sit in patiently, listen to the particular arguments, and I'm sure in your usual efficient way, and I hope accurate, broadcast it to the public, and everybody will be able to hear what the arguments on both sides will be. And when the judgment is delivered, I am sure the judges, given the circumstances of this case, and given especially the fact that it was a Privy Council instruction or directive for the issue to be considered by the local court, they will give their judgment